Hello, and welcome to another presentation in our series of Supremus Group's Patient Awareness Briefs. Each one of these 15-minute sessions addresses a topic of direct importance to you as a consumer of healthcare services and explains an aspect of the regulations as they deal with how you should be informed and engaged in the healthcare delivery process. This session is about the Notice of Privacy Practices and how this important document should be given to you and what this important document should mean to you. So let's get started. Slide 2. So today's session is about the Notice of Privacy Practices. During this session, we'll talk about what your privacy rights are under HIPAA, what the notice is and what it says, what you yourself should be doing about your privacy, and how to get informed and get engaged. Slide 3. This information about you is collected, used, and disclosed by the doctors, dentists, and other professionals who provide care for your health. This information is vital for your healthcare providers to keep track of your medical history and the claims filed for it. The law requires that they always exercise caution in the handling and using of it, and places requirements on them to protect your information and conditions on how it will be used or shared. In this session, we'll discuss this information and what the Notice of Privacy Practices means regarding the use of your health information. Slide 4. Now, as you can see from this diagram, there are several different ways of looking at this information. We have health information, which is the entire universe, you could say, of what informational elements could be contained. Then we have within that individually identifiable health information. This is all of the information that can be about you. It identifies you specifically, and it doesn't matter what form it's in, whether it's written, electronic, or spoken. Within that, we have a smaller subset commonly called PHI, or Protected Health Information. This too is individually identified, but it comes in a specific form. It comes in the electronic form. And then we have the ePHI, or electronic PHI, which is another term that can be used interchangeably with Protected Health Information, or PHI. Now, each one of these types of information has certain elements within it, and each one is used for slightly different purposes. So, what do they all contain? Next slide. Slide 5. The elements of individually identifiable health information include some or all of the 18 identifiers you see on this page. They're everything from the demographic piece, which describes who you are, where you live, what your phone number might be, what your fax number might be, emails. It also includes your Social Security number, a medical record number, and various other identifiers to the tune of a list of about 18 different elements. Some of these elements will be in the Protected Health Information, or PHI. All of them are contained within what we call individually identifiable health information. Slide 6. So let's talk about this Notice of Privacy Practices that governs how you're going to be interacting with your providers and how this information, this individually identifiable health information, can be collected, used, and disclosed. The notice itself, which we call the NPP for short, is a document that each providing organization and professional themselves, if it's a doctor in his own office, is required to have and to provide to each of its patients. What it tells you in short descriptive statements is how you can get better informed about what your health information is and how you can exercise certain control over it. It's normally presented in 4 different sections. First would be patient rights. Second would be the provider, known as a covered entity, what their obligations are. Third section usually covers all the permitted uses. More on this later. And the last section is about the complaints process, how you can file them, where you can file them. Now it describes this process and what happens in it. Gives you names, addresses, and phone numbers. It also includes all of the information necessary to contact people at the Office for Civil Rights in the Department of Health and Human Services in Washington, D.C. In some states, there may be an office usually connected with the state government for consumer rights protection, and they may want you to file a complaint there if you so desire. Slide 7. So who is the Notice of Privacy Practices for? Well, it's for you and anyone who asks for it. Is it really that important? Absolutely. It is one of the main forms of communication you have with your provider about your privacy and about your information. They should be written in plain, easy-to-understand language, and there are certain things, certain specific language that they must contain. So as an example, what is called the preamble, the opening paragraph of the Notice of Privacy Practices, it normally would read like this. This notice describes how medical information about you may be used and disclosed, and how you can get access to this information and exercise your rights regarding it. Please review this carefully. That's very important advice. You should always make it a point to read this notice and become familiar with it. Although the law doesn't specifically require it, many providers, as a convenience and a courtesy to their patients, produce multilingual versions so that they can serve their patient populations better and ensure that they get properly informed. Slide 8. So let's talk about your rights. First on this list, you can request to inspect or obtain a copy of your medical record and the associated claims history. This is what is called the Designated Record Set, or DRS for short. You will likely be asked to make this request in writing, and they probably have a form for that purpose. You may find that there is a charge associated with this, obtaining a copy, which you can get in either paper or electronic form, and the law does permit them to charge you for this. But the cost normally must be limited to the cost of the labor and materials involved with making the copy. Whatever this charge amount is, it must be shown in the NPP so that you're fully informed, much like any other consumer awareness notice might be. And it needs to let you know how long it will be before you can get the copy that you've asked for. For example, it may say, we will provide a copy of your records within X number of days of your written request. If your request is urgent, please ask to see our office manager for immediate assistance. Normally they realize that there may be reasons for a hurried request to obtain a healthcare record. Medical emergencies arise whenever they arise. And so they will normally have a way of handling exceptions, emergency or urgent types of situations. So be sure to ask about that if that need arises for you. Slide 9. You can request, again in writing, that your provider make an amendment to your record. Now when you do this, and this of course usually follows your reviewing your record or your claims history, you should be prepared to provide evidence to support your claim that something is incorrect or that something might be missing. Your provider is not required by law to make any modifications to the record unless you can support your contention that the record is inaccurate. Your medical record is, from the very first moment that pen touches paper, it is a legal record, and it cannot be modified except by verifiable, authentic information. And that information cannot change what's there, but only amend it by a later entry. So you need to be sure that you've got the evidence to support your claim of something missing or something being incorrect. You can request, in writing, an accounting of disclosures of your information for any purpose other than for what we call the normal process of business in healthcare, treatment, payment, or healthcare operations, or when you have specifically authorized its disclosure. There can be no charge for this, and the time between request and providing the report must be shown again in the NPP. Slide 10. You can request in writing certain restrictions to be placed on the uses and disclosures of your information. For example, you can restrict its release to almost anyone, except for government and other official uses. For example, law enforcement, the military, correctional institutions, or other official purposes. You can restrict its release to your health plan regarding out-of-pocket expenses. You can even restrict it from any individual that you wish to. You can request that your provider use an alternative means of communication. Most providers try to accommodate this, but sometimes it's not feasible. For example, you can ask your provider to communicate with you via email, but if he cannot do that securely, so that your information is in no way exposed except to you as the receiver and to him as the sender, then the law really suggests, in fact mandates, that he not provide it that way. So this may be a cause for you to negotiate with him how that can be done. Most providers will accommodate a request that's reasonable. And you have the right to file a privacy complaint with the provider, normally with their office manager or whoever functions as the privacy officer for them, or with the Office for Civil Rights, and have no fear of retaliation or a denial of service. As I mentioned before, you might also be able to file this with your state's Consumer Rights Department if you have one. Always be sure to ask your provider if that's available. Now the next section, slide 10, the next section we talk about the provider's legal obligations, what the law requires them to do. For them, the requirements are very few, but they are very strict. Typically, they revolve around that they must protect the privacy of your information. They need to provide you the notice. Obviously, they need to abide by the terms to protect your health information and use it only as necessary to deliver care and get things billed for. And they need to notify you anytime that there is a change in the notice, typically by offering you a new one. Normally, they will offer you a copy on every visit. They'll maintain a printable copy on their website, and when they offer one to you, they'll ask you to sign a receipt so that they have a record that you were given the most recent version. This is important for them because they're often asked by the government when the government comes to visit, how regularly do you give your patients your notice of privacy practices? That receipt is their proof that they give it out as the law requires. Slide 12. Now the permissible activities, these are things that the regulations permit your provider to do in making use of your information. Now they are required to inform you that they do this, or that they are allowed, permitted, or even required by the law to do this. You need to be aware that they don't need to ask your permission for this. But in some cases, you are allowed to opt out if you don't wish for that to be used. They're allowed to provide you appointment reminders. Typically, this involves a postcard of some sort, or possibly even a voicemail, giving very, very limited information, such as date, time of your appointment. They can describe or recommend treatment alternatives to you, which they believe is a benefit to you, so that you're better informed about what alternatives you may have. They can provide you information about health-related benefits and services. Given what they're treating you for or seeing you for, this might be something you might be very interested in. Many times, providers will support local charitable causes, such as runs, 5K fund runs to support the fight against cancer. These are noble causes, but not everyone is interested in supporting them. So these things here you are able to opt out of if you so choose. Slide 13. Some of these permissible activities relate directly to your health and safety. For example, if you are taken to your doctor's office by someone, normally the doctor will assume that you have an open relationship with that individual, and when it comes time to talk to you about what has transpired in the office that day, out of courtesy, they will invite both of you in. At this point, you're able to say, no, I'd prefer that you speak only to me, or you can allow the other person to go with you by saying nothing. This is entirely your option. But if you object to that person coming in with you, they will honor that, and they will not speak to you with that other person present. But there are times when you might find yourself being brought into the emergency room or into your doctor's office, and you're not able to speak for yourself. In such cases as that, the individual who brings you in or accompanies you in will be the person the doctor will address their questions to, obviously in pursuit of what's happened, what put you in that state that you're in, and so on. But when you have regained yourself, and you're able to speak on your own behalf, if you choose that the doctor should speak only to you from that point, the doctor will honor that request. Slide 14. Now, the next section of the Notice of Privacy Practices talks about required uses and disclosures. You should be aware that the law places certain mandatory requirements on the providers that are not optional for them. These do not require your permission either, but again, you need to be informed of what these requirements might be. Now, these required uses and disclosures include a number of things, mostly having to do with providing information to official requests from official sources and having to do largely with managing aspects of public health. For example, certain public health activities, there are diseases and conditions that are reportable to the public health department. Contagious diseases such as smallpox, influenza, and others. There are limited law enforcement purposes for judicial or administrative proceedings, for example, in the appointment of a custodial adult for another person. If they come across a suspected case of abuse or neglect, they are required to report that as well. In cases of health oversight, if the military should request information on someone joining, or if there's any additional information for someone who's already a member, if there is a reason of national security, or to correctional institutions, since they have to provide health care for the offenders that reside in their locations. And then any other specific request or requirement to obtain this information that the state or federal law may require. Slide 15. So we move on to the Notice of Privacy Practices final section, the complaints filing process. Now, you'll be able to file a complaint with the proper authorities. Your state may have an office for this, as I mentioned, or it may be with the Office for Civil Rights in Washington, D.C. If you believe that your privacy has in some way been violated, you can file a complaint with these agencies. Usually, the filing would be in writing and made to the NPP, providing the address for your written complaints. It could be to the provider office itself, the Office of Civil Rights, as I mentioned, or if there's a state-level office. Now, these requests may be in writing, or you may have the ability to file these in a web-based complaints form at any one of these locations. If you're going to file a complaint, you should be prepared to provide evidence that supports your contention that your privacy has been violated. Now, the law makes it very clear that the provider cannot retaliate in any way for you filing a complaint, so you should feel free to do so if you feel that you have legitimate cause for doing it. Slide 16. Slide 17. Now, as a patient, you are of central importance in managing your health care, your information, and your participation in the process. As the patient, the subject of this information, you have the ability to exercise a great deal of control over it. Your providers will make use of this information to ensure that they are giving you the best care possible. And they will make several different uses of it for that purpose. But the reality is occasionally some of this information goes astray because something has gone wrong somewhere. Someone's mishandled something, someone's misaddressed something. Sometimes these are accidents. Sometimes they're unfortunate circumstances. Whatever the case is, though, these things do happen. So you need to be an active team member. And by learning how this information is handled, used, collected, and disclosed, how it's processed, and who uses it, you can be an active team member by learning what needs to happen with that information and to hold your providers and their associates accountable for what they do and making sure that they always protect it and use it in a proper way. Slide 18. So what do? First thing to do, of course, is to get informed and get involved. This information, after all, is about you, and you need to know what it is and how it's used. If you have any questions about any of this, your first point to ask them should be of your provider. And they are often only too happy to get your involvement and answer your questions. So we hope that this information has proven to be valuable and that it will help you make the very best decisions regarding how you will manage your participation in this process. Thank you for joining us.